The network is blessed to be associated with attorneys who genuinely care about liberty, and that passion is reflected in our most popular monthly column in our online journal, The Attorney Question of the Month. Since joining efforts with us in 2013, several times a year, Dallas, Texas attorney Menashe Sasson contributes to that column. And when that happens, anyone who loves to learn puts on their glasses and grabs a pen and a notepad and settles in to study, because his contributions are supported with detailed citations from the law or laws bearing on the topic under discussion, and he explains what it all means. We appreciate those scholarly commentaries because the material exposes us as laypersons to the language of the law and then explains what it means. Maybe that's not too surprising because he worked as a police officer and major crimes detective for 12 years before attending law school, and before that he served in the U.S. military. Additionally, Menashe is an NRA-certified pistol, concealed carry, and rifle instructor, and he's a range safety officer. A lot of his cases concern folks who have background issues that prevent them from passing a 4473 gun purchase background check, and other clients are at odds with the Bureau of Alcohol, Tobacco, Firearms, and Explosives, the ATF, over their federal licenses to sell guns. I mention that because it's not unusual for people to say they'd like to become armed citizens and join the network, but they're prohibited from possessing firearms. Other times people think our focus is only on self-defense with firearms, which they imagined happening outside their homes, but where they live, ordinary people can't get carry licenses. While our work on behalf of members is 100% focused on the legal defense of use of force in self-defense and doesn't entail restoration of rights or getting permits to carry, the questions arise often enough that I think it is well worth our time to explore them, to ask Mr. Sasson, as Tolkien once wrote, to read the portents and explain if decisions the U.S. Supreme Court has been handing down over the past few years are creating change. And it'll be interesting to learn what you know about that. I appreciate you coming on the show today and sharing your knowledge with us, Menashe. What else would you like us to know about you besides the fact that you're not our attorney and this doesn't create an attorney-client relationship?
Well, that's a very important point, but I just want to emphasize this is for educational purposes, and I can't give legal advice to anybody because this is just really not an appropriate forum for that. But we do encourage learning, and what I want to start out doing today is talking about several different cases and how they fit together and see the progression of the law. A lot of non-lawyers, lay people if you will hear, oh, the Supreme Court decided X or the Supreme Court decided Y, and then that's, for them, the end of it. But in reality, the law is not just one discrete case. It's reading cases together, seeing the development, and seeing how they work together, and sometimes how they do not work together. And so that's kind of where I'd like to start today. And any questions you have that the audience would probably be thinking the same thing, I'd welcome you to interject those.
Well, that sounds good. And, you know, in kind of our introductory study, you called it a trilogy. And I thought that was good, that there were, in the past decade or so, 3 major cases that, and I like your description of that evolution, how they interact and connect. And let's just jump right into what you've called a post-Bruen perspective on Second Amendment law. Okay,
very good. So the trilogy that we talked about, of course, is cases that everybody's probably familiar with, or most people listening to this are probably familiar with anyway, is the Heller decision, the McDonald decision, and now most recently the Bruen case. Okay, so rewinding all the way back to 2008 in the Heller decision, Dick Heller was a guy who lives in Washington, D.C., place where a lot of us probably wouldn't want to live. But he's a police officer there, or at least was at the time of all this. And he figured, well, I carry a gun at work. Why can't I have one at home? And so he filed a lawsuit. He and some other folks filed a lawsuit. And the legal issue that was raised by that lawsuit is whether the District of Columbia prohibition on possession of firearms, even in the home, was constitutional under the Second Amendment. Okay? And really what the issue was is, does the Second Amendment protect a individual right of people like you and me and everybody else? Or does it protect a collective right, the right of the militia? And because, you know, the Second Amendment talks about a well-regulated militia. And so the main holding in that case was that the Second Amendment protects an individual right, which that's huge, because if the court had held the other way, that would have just opened the door to nonstop gun control and abolition eventually. Okay, if the militia, if the right was a militia right, then that's a collective right of the state essentially, and not an individual right. Okay, so that was the main holding. And so another important thing, we're going to see this come up a little bit later, is the Second Amendment actually protects two rights: the right to keep arms and the right to bear arms. They're different. Okay. So that's the good news for us. The perhaps not so good news, and I'll quote, this is what the court says in its opinion in Heller specifically. It says, the court's opinion should not be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons, the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions on qualifications of the commercial sale of firearms. Okay? So that's what the court said on that, and that's kind of a negative, because we see, as we'll see a little bit later, the sensitive places and all these regulations and that kind of thing can be a big deal. All right? The good news on the other side of that, though, is that the court made another comment that opens the door to litigate these. There's a case that it relied on in Heller that it was talking about a case many years ago challenging the NFA, where this guy got arrested with a sawed-off shotgun. Okay, and that case essentially held that the NFA prohibitions on shotguns and machine guns and so forth and so on are constitutional. Okay, so there's two problems with that holding. One is that was, many years, decades before Heller. Okay, and so the courts weren't looking at the possession of firearms in general as an individual right. And second, and perhaps more importantly, is the court in that opinion said that the reason for its ruling was that in the absence of evidence tending to show that possession of a shotgun was not, short barrel shotgun that is, was not consistent with the history and traditions. That's the support for the court's opinion way back then, okay? And so the court really, I would argue, if I were arguing this case today, it would be that the court, even though this case held that sawed-off shotguns could be prohibited by the NFA, that's no longer true. One, because Heller recognized that this is an individual constitutional right, not a collective right. And two, the court that held in the sawed-off shotgun case that the NFA was constitutional did so because there was an absence of evidence, not because the evidence showed what the holding is, or not because the evidence supports the holding.
Which one is the sawed-off shotgun case? Is that the 34?
Yes, it is. It's Miller. U.S. v. Miller.
Miller.
30s sometime. I'm not sure if it's 34 exactly, but yeah.
Yeah, I'm not sure either.
Okay.
Interesting.
Yeah,
Thank you.
Decades old. Century old almost.
Yeah, very. Yes.
Okay. So the next case in our trilogy was McDonald. Mm-hmm. Okay. And yes. McDonald was factually indistinguishable from Heller. Okay.
Really?
From a perspective of the relevant facts of the case, okay? McDonald, unlike Heller, was not a police officer. McDonald, unlike Heller, didn't live in D.C., right, and so on and so forth. But the idea...
He lived in Chicago, I'm not sure.
He lived in Chicago, exactly right. He lived in Chicago. But the important facts are the same. McDonald, like Heller, was a law-abiding citizen. Illinois, Chicago, like D.C., had a ordinance that prohibited the possession of firearms in the residence even, unless there was a permit. And D.C., like Chicago, made it effectively impossible to get a permit through all this bureaucratic red tape and so on and so forth. Okay? So from that perspective, Heller and McDonald are indistinguishable from a legal perspective. So you might ask, why did Heller need to come, or why did McDonald need to sue, right? If the Second Amendment protects an individual right in D.C., well, surely it does in Chicago, correct? Should be. So the reason for McDonald is that prior to Reconstruction, prior to 1865, when the Civil War ended, and the Reconstruction amendments were passed, the 13th, 14th, and 15th Amendments to the Constitution, the Bill of Rights, including the Second Amendment, applied only to the federal government. States were free to violate it wholesale. Okay? So prior to enactment of the 14th Amendment, which parenthetically incorporated the Bill of Rights and applied it to the states, made it applicable to the states. All right. Prior to the 14th Amendment in 1865, the FBI would need a search warrant to search your home, but the Chicago police would not, and it would not be unconstitutional.
Oh, goodness. Okay.
So that's the issue. If Heller had lived anywhere but a federal enclave like D.C., we wouldn't need McDonald. Okay, so McDonald fills in the gap on that one. Okay. So the interesting thing about Heller is that the Reconstruction amendments were needed right after the Civil War, and why would that be important for a firearms perspective? Because the Southern Democrats were passing Jim Crow laws, and many of those laws disarmed black people.
Exactly.
Okay.
Yeah.
And so, in order to try and assure that the laws applied to everybody and the Constitution applies to everybody, one of the provisions of the 14th Amendment is that blacks get the same rights as everybody else. Okay?
Right.
So, I found it kind of ironic that Otis McDonald, lived in the South as a child, and as he grew up and after he had some military service and got out and went to make his life, he moved to the North, Chicago essentially, and started his life there, still trying to get away from the Jim Crow laws.
But it followed him.
It did. In fact, I think we have a clip that we can play from Mr. McDonald himself, in a couple minutes to hear from him personally.
I'm Otis McDonald, and I'm 77 years old. I was in the armed forces in Germany for 2 years, 9 months, and 21 days. When the situation in my neighborhood got a little hairier than I could live with, I knew then that something had to be done. And even though I knew I was going to be denied, it was still devastating to live where I live and be surrounded by what I was surrounded by, and seeing every day on the news what's happening to elderly people my age. And to go down there and then they say, no, you can't have a handgun. I just wanted to protect myself and my family and my property. I come to realize what it meant to so many and the country itself. A long time ago when I was a child, my mother used to teach me about values. And she would always wind up saying this phrase, Otis, if you don't in life find something that you will give your life for, you really haven't lived. most of the politicians that's trying to deny me the right to protect myself has armed guards 24/7. So that tells me that they could care less about me. And that's hypocritical. When I heard Justice Thomas's reading and how far-reaching back that it went, it was really, really touching.
I can't imagine anybody more in need of having the right to armed self-defense than that gentleman was. It's being someone who's not lived in a big city like Chicago, it's nearly unthinkable to me that people didn't have the ability to use similar force as what the criminals were bringing against them. And yet there he was. And so he courageously brought suit. It made it all the way up to the Supreme Court. And what happened then?
So the Supreme Court held, and before I tell you the holding, this is typical in 14th Amendment jurisprudence where since the 14th Amendment was enacted, it wasn't a wholesale application, incorporation, and application of the Bill of Rights to the states. It's been a piecemeal incorporation. So there was cases addressing the First Amendment. Okay. Now we have McDonald, the case addressing the Second Amendment. There's been cases addressing the Fourth and Fifth Amendment, and so on and so forth. And so it's not assumed that just because the 14th Amendment was enacted, that all of the rights in the Bill of Rights are automatically applicable to the states. It's been piecemeal legislation or piecemeal litigation. And so that's why Heller, or that's why McDonald, was needed to be litigated in the courts, and especially the Supreme Court, to set a nationwide rule saying that, yes, the Second Amendment applies just like the First Amendment applies to the states, just like the First Amendment, just like the Fourth, Fifth, and so on. Okay, so the holding, obviously, in McDonald is that, yes, the Second Amendment applies to Chicago, Illinois, and every other state, including Hawaii, who we're just having some litigation on recently, thinks that their opinion is more carries more weight than the U.S. Supreme Court's weight, but that's another case.
It is. So if the McDonald holding solved some things, did it also leave open some doors for continued restrictions? I'm seeing a progression here, an evolution.
That's exactly right. And yes, it did. All that Heller and McDonald addressed is whether a person may lawfully, under the Second Amendment, possess a firearm in their home. Okay, it didn't say anything about carrying firearms in public. Well, remember earlier, a few minutes ago, we talked about the Second Amendment protecting two rights. One, the right to keep arms, and two, the right to bear arms. Okay, Heller and McDonald addressed the right to keep arms. Now we come down to Bruen, which addressed the right to bear arms. Okay, and before we dive headlong into Bruen, most states have not allowed open carry or unlicensed carry for many years. Back in the day, that was kind of what happened. But in modern history, in order to carry a firearm in public, a person had to have a license, right, issued by the government, the proverbial permission slip, right? So there's two types of licenses that have evolved over time. One is what we call the shall issue, and one is what we call the may issue. So a shall issue is pretty much what it says. If a person's not a criminal, felon, otherwise prohibited by law, the government must issue the license after they jump through the hoops of applying, paying the fee. Sometimes there has to be a test on can you shoot the gun, and that kind of thing, right? Or knowledge of state laws and so forth. But at the bottom, at the end of the day, in a shall issue state like Texas, once a person satisfies all the objective criteria, the government has no choice but to issue the license. Okay. In a may issue state, all the same criteria must be met as in the shall issue states, with the exception there's an additional criteria that some government bureaucrat must come to the conclusion that the applicant has shown, quote, good cause, unquote, or some analogous language, okay? Illinois, California, New York, all these cases, all these places were, in Hawaii, were shall or may issue states. A person applying, an applicant had to show good cause. Well, that's where Bruen came in New York State Rifle and Pistol Association versus Bruen. So the long story short there is that Bruen said the 14th Amendment applied the Second Amendment to the states, just like it did in McDonald in the context of owning or possessing firearms. Likewise, in the context of carrying firearms, it must the rights incorporated there as well. So not just one portion of the Second Amendment, but the whole Second Amendment is incorporated and applies to the states. Okay. So as a aside to that, then the question comes, and this is just beginning to be litigated, but the general theme that seems to be emerging is that a state doesn't have to allow all kinds of public carry. They just have to allow one kind of public carry. Okay?
And what kind would that be?
Well, that's their choice. So far, the cases, and this may change over time with more litigation, but essentially what it's saying is that on the most restrictive level, if it allows licensed carry after going through the shall issue process, and it issues a license that way, then it doesn't have to allow open carry, for example. Or it doesn't have to allow what's called constitutional carry, or usually more accurately, permitless carry. Okay? And constitutional carry and permitless carry are two different terms. They mean different things, even though people use them interchangeably. But the bottom line from the Bruen perspective is that this type of regulation, if a state says, for example, we're going to allow permitted carry, then we can outlaw open carry, permitless carry, and the like. Okay. Now, of course, states can go beyond that, and they can allow all kinds of carry. But we're talking about the less than cooperative states here.
Yes, the other side of it. And so back to that open door for restrictions that unfortunately kind of Heller didn't completely close off. Of course, the big fallout of Bruen has been the sensitive places. How is that even passing muster?
Well, that's the proverbial exception swallowing the rule, and that's the litigation that we're going to be facing. In Bruen also set out a test to determine how for lower courts to apply to challenges to regulations, so these lower courts can determine whether the challenged regulation is constitutional. And that test essentially is, does the regulation implicate a Second Amendment interest? And if it does, it's presumptively unconstitutional, and the state has the burden of showing that there is a history and tradition of this type of regulation. Okay? All right? So we have different laws that might be held unconstitutional, okay, under the Bruen test. Let's start with federal law. The first one is prior felonies. Okay, in this environment, there are more federal felonies now than there have ever been before in history, and just about everything is criminalized, right? And so, from a perspective of firearms rights, the Gun Control Act of '68 makes no distinction between violent felonies and nonviolent felonies. Okay, and a very good case can be made, I think, now in the wake of Heller McDonald and Bruen, that needs to change. Okay, I had a client a while back, nice man. Unfortunately, had a run-in with the IRS, and ended up in trouble getting convicted of a felony related to filing tax returns, or more accurately, not filing them. Okay, and he's now a prohibited person, but there's no violence involved. The rest of his life has been, he's an upstanding citizen, works, pays his taxes, the whole 9 yards. He slipped one time. It was nonviolent, and that took away his Second Amendment rights. And there's a lot of people in this position that they make a mistake, and it's a nonviolent mistake, and that dooms them for life as far as Second Amendment rights go. Okay, I'll take it a bit further, and this is just my personal opinion. This is not the law, but a lot of us think of the concept of you get in trouble with the law, you do your time, and it's over with, right? You're back to being a citizen, right? Well, that's what it should be, though. I mean, why should someone who has a criminal conviction be stigmatized for life with that criminal conviction? Have they not paid their debt to society?
Apparently not, because voting rights and all kinds of other things, this is not just a gun rights issue.
Right. Exactly right. It's not. And one of the reasons for such a high recidivism rate, and this will be unpopular with a lot of folks, but one of the reasons for such a high recidivism rate is because of the stigma attached to criminal convictions, which inhibits or prohibits or inhibits them from getting employment, housing, and so on and so forth after they've served their time. Okay. Now, of course, we need to balance their interest in reforming their lives and getting the opportunity to move forward. We need to balance that on the other side of the coin with the protection of society from recidivism from violent crimes. Okay. But back to our topic, there's no reason that I can see that makes any sense for prohibiting nonviolent felons from possessing guns. Okay. Another area where we see all kinds of mischief is on mental health issues. Okay. And for example, veterans who seek help from the VA after coming back from a war zone and may have trouble sleeping and take medicine for a little while or something like that, they get reported to the federal government, and they can't pass a 4473 check anymore. Okay. And again, we want to keep firearms out of the possession of people that have legitimate mental issues, but we don't want to stigmatize somebody, especially who's served their country and had little PTSD, and now they're fine. Okay, so that needs some tweaking and some refinement as well. Okay. Also, to the community at large, or to the nation at large, there's a lot of people, and I see them in my practice all the time, where they have a temporary mental problem, and what commonly happens is the police come out and take them into custody, put them in what's typically a 72-hour hold or so to be evaluated, okay, and then they're released, all right, and they're fine. There's no problems. And they've not been committed by a judge. There's no involuntary commitment, anything like that. It's just that long term, the initial 72 hours was involuntary, but the law on that says that 72-hour evaluation period is not considered an involuntary commitment, and they don't lose their rights over that. However, they're being reported to the FBI. And they're effectively losing their rights when they shouldn't lose their rights. Okay?
No wonder people don't seek help when they begin to manifest those problems, because who would want that hung on them?
Correct. Exactly. Yeah. The stigma of mental health problems is quite onerous.
Yes.
So. So that's kind of the big things that we're seeing on a national scale. Another one is reporting by the states of disposition of criminal cases. So let's say someone's arrested and charged with a particular crime, and they're either they plead it down to a case that would to a conviction that would not make them a prohibited person, even though the original arrest and charge was for an offense that would make them a prohibited person if they were convicted of that. We see the arrest getting reported, but the disposition never getting reported to the FBI, and they're considered prohibited persons until people like myself have to go in and straighten things out. Okay, and so even though the court clerks are required by law to submit the dispositions, there's a breakdown in the system somewhere where it doesn't always happen. And so,
and is that on the state level? So the litigation happens, like you said, people like you suing Texas to report that outcome?
well, see, here's the problem. State laws typically require reporting. Texas does, okay? And reporting of not just arrests and convictions, or not just arrests, but also of convictions. And if you plead it down, that's supposed to be reported too. But there's a disconnect. I've got a case right now where a guy, my client, and his now ex-wife agreed to a mutual restraining order in a divorce case that occurred somewhere out of Texas. And it wasn't because anything bad happened. It was just mutual. They agreed to it in the process of their divorce. And my guy went back into court through his out-of-state lawyer and got that restraining order rescinded. But now we have to get it showing up as being corrected on his federal record so that he can possess firearms. Okay, and the hang-up seems to be that the reporting agency, in this case, not the court, but the police department, where the order was recorded and put into the federal database, has just not done anything to pull it out. Okay, so we see all kinds of little problems like this.
Well, and the domestic violence, I guess the words convictions, although I'm not even sure that that's appropriate, has been with us for years since the Lautenberg Amendment. Things that weren't even felonies were making people into prohibited people, and I see that that's continuing to be addressed as we're evolving our way through what prohibition society thinks is appropriate, or that the court thinks is appropriate, and what prohibitions aren't. So where do we stand as far as domestic violence, which relates right to that restraining order you spoke to?
Okay, so domestic violence is a hornet's nest, if you will. There's a lot of litigation on that in the Supreme Court. Most recently, there's a case called U.S. versus Rahimi. Okay, and where what happened in Rahimi was essentially he got arrested for having a firearm while under a domestic violence restraining order, and Rahimi challenged that on Second Amendment grounds. And long story short on Rahimi is the court said, sorry, if you have a domestic violence restraining order, then you can't have guns. Okay, and the dissent in Rahimi pointed out that that's not a historically consistent outcome with the majority's holding, and so to get to that decision in Rahimi, the Supreme Court had to violate its own rule that it set down in Bruen. Okay, yes, the Rahimi case, the TRO, the restraining order prohibition, certainly implicates the Second Amendment. Okay, that's the first prong of the test. But the second prong, of having a historical precedent for that, wasn't there. And the majority in Rahimi danced around that, and the dissent called them out on it. But this Rahimi is a very good example of bad facts make bad law. because the judges just didn't want to be go down in history as being the ones that voted to allow domestic violence people with restraining orders have guns. That just is bad press, right? And so that's how Rahimi came to be Rahimi. On a different note, and probably more pernicious note, there was a case back from 2009 called U.S. v. Hayes, and I think nothing to do with
Not me.
nothing to do with you or Marty, right? So here, now Hayes is a very interesting case, and I'll tell you, it's one that I think is wrongly decided and ripe for reconsideration. But in 1994, a guy by the name of Randy Hayes was convicted in West Virginia of a misdemeanor crime of battery. Okay, so far so good, right? The West Virginia statute, battery statute, is what we call a generic battery statute, and it doesn't require proof of the existence of a domestic relationship with the victim for the state to obtain a conviction. It's just a battery. So committing a battery under this statute in West Virginia was no different whether you hit your wife or whether you hit the guy across the street during an argument. Okay, it's just a generic battery case. Okay, and we see this all the time where people plead to people are charged with offenses that would be a domestic violence offense if they're convicted of it. That wasn't Hayes' case, but then they plea bargain it down to something that would not be a domestic violence offense. Okay, and that's what they plead guilty to. So fast forward in Randy Hayes' case. So he had his 1994 conviction. 2 years later, in 1996, the Gun Control Act was amended to insert domestic violence convictions, okay, in addition to felony convictions. So now we got any felony, and added to that we have any misdemeanor crime of domestic violence. And as we're about to explain, the term misdemeanor crime of domestic violence is a term of art that only lawyers can twist to mean what they say it means, okay? So to recap, 94, Hayes gets convicted of misdemeanor battery. 2 years later, in 96, Congress adds domestic violence convictions to the list of prohibited persons. And then fast forward to 2004, okay, so some 10 years after his battery conviction, the police go to Hayes' home on a 911 call of domestic violence, right? And during that encounter with the police said, well, may I search your house? And Mr. Hayes says, well, yes, you may. Well, that's maybe not the first mistake.
That's another problem.
Maybe that's not the first mistake, but that's certainly a big mistake, okay? Hayes consented, and lo and behold, the police find a gun, right? Now, these are city cops or local cops, right? Somehow this makes its way over to the U.S. Attorney's Office, and the federal prosecutors charged him with being a felon in possession of a gun, or a prohibited person because of the domestic violence conviction in possession of a gun. And that is a 10-year federal felony, okay? Unlike the misdemeanor crime of domestic violence, which would only be a 1-year max sentence, right? So Hayes appealed his conviction all the way up to the U.S. Supreme Court, and his issue was that the West Virginia statute just says that battery is an unlawful or offensive touching of one person to another. There's no element in the West Virginia statute that the victim has to be in a domestic relationship with the defendant, and therefore, I, Mr. Hayes says, was not convicted of a misdemeanor crime of domestic violence. I was convicted of a misdemeanor crime of generic battery. And you know what the Supreme Court said, the U.S. Supreme Court? It says, not so fast. It says that any generic battery conviction will suffice as a misdemeanor crime of domestic violence, as long as we can look behind the curtain at some point down the road and see whether the victim was in a domestic violence or was in a domestic relationship with the defendant. And so that is
after the conviction.
After the conviction, right. So we see this all the time. People will call my law firm and say, well, I'm having a hard time getting my Texas CCW. We call them LTCs down here, license to carry. I'm having a hard time getting my Texas concealed carry license because 20 years ago, me and the missus had a little spat, and I had this little conviction, right? And it turns out that not only are they ineligible for a carry license, they're prohibited under federal law from possessing firearms for the rest of their life. And it doesn't matter that, for instance, they're still married to the spouse, 20 years later, and never had any other problems or that kind of thing. So through that, the Supreme Court kind of really changed the whole meaning of what is, right? The dissent in that case said, it cannot fairly be said here that the text, quote, clearly warrants, unquote, the counterintuitive conclusion that a, quote, crime of domestic violence, unquote, need not have domestic violence as an element. That leaves the majority's argument about legislative history and statutory purpose. This is not the, quote, rare, unquote, case in which such grounds provide, quote, fair warning, unquote, especially given that there is nothing wrong with the conduct punished, possessing a firearm, if the prior misdemeanor is not covered by the statute. An individual should not go to jail for failing to conduct a 50-state survey or comb through obscure legislative history. 10 years in jail is too much to hinge on the will-o'-the-wisp of statutory meaning pursued by the majority.
And that was Chief Justice Roberts, wasn't it? Wasn't he the author of that dissent? So I thought that was interesting. He hasn't always been real popular with us strict constitutionalists, and I thought it was interesting to read his language and him trying to parse those paragraphs and counteract what the majority was saying. That was an interesting case, and I hadn't studied it until you brought it to my attention. I rather fascinated by the whole thing. So where did we go from Hayes? What has been the evolution trying to recover from that?
Well, we still need more. Hayes was that was what 2009.
2009. Yeah.
So there's an argument to revisit it and try and get it overturned. But then there's a good argument to not overturn it. That's one of these things we're just going to have to wait and see what happens. Good lawyers on both sides could make good arguments. I think that Hayes was wrongly decided, but that's just my personal opinion, which is, that and maybe $5 now would buy you a cup of coffee.
Was it the makeup of the court at that point? And I don't know. I mean, we're a little stronger now, but are we strong enough now that it could make any difference?
Well, that's hard to say, because if you look at the court just from the superficial perspective of who appointed the justices, and then you extrapolate from that what we might expect from those justices, there are many times when a person would be sorely disappointed in the outcome of certain cases. Okay.
Yes. Yeah.
So we can't say that, well, these X number were appointed by our guy, and those Y number were appointed by the other guy or the other party, and therefore we have a majority or a minority in the Supreme Court. It's not that simple. So, where we're going, it's hard to say. But it's ripe. It's a litigator's wonderland. It's ripe for litigation. The bad news is that, of course, litigation costs money, and to get anything to the Supreme Court costs a whole lot of money, and most people just don't have the time, the money, or the inclination to do that. Okay. So from a individual perspective, the landscape looks favorable, but there's still a lot of landmines on our path. Okay, and as we've seen lately, It doesn't matter who you are, you can be pursued almost indefinitely in the courts and
Yeah, yes.
to get the desired outcome. Okay.
So where do we go from the domestic violence? Because you talked about there being a need for the national, what is it? The National Instant Background Check, Criminal History Background Check, NICS, as we call it. How would a person go about getting reform of that to maybe get out from underneath these nonviolent felony convictions and so on?
To get out of the nonviolent felony convictions, that's going to take legislation. Okay, the Gun Control Act is going to have to be amended through Congress and signed by the president. Perhaps there is good news on the horizon for that, but someone needs to coordinate that and get the legislation introduced and get support behind it and so forth. The usual lobbying that takes place on any legislation. So perhaps there's been a lot of pardons here lately in both parties, going back on criminal things, and perhaps the people that want to pardon all these folks, and some are legitimate. I don't have any issue with some of the pardons, but maybe they'd like to nip this whole thing in the bud and change the law so these folks are not convicted in the first place. And a good place to start would be to exempt non-felons from the current law.
Indeed. So that's not going to happen in the courts. That's going to happen in
Congress.
The
So
Senate.
it's got to start in Congress,
Yes.
and ultimately go to the president.
Indeed.
Another reform we could do, and this one could be done quite easily, I think, if someone had the interest in pursuing it, someone in the right places, is to reel the FBI back in just at least a little bit, and get them to do what they're supposed to do, and get away from doing what they're not supposed to do doing what they're supposed to do, and treating Americans fairly and getting things reported accurately, and keeping the records properly.
Well, that goes to what you said earlier about what he was charged with was not what he was convicted with, and yet he's still prohibited as if the original charge stood.
And what the FBI always says when we contact them about this stuff is, well, we just are a repository of data. If the data is not right, you need to go back to the source and get it corrected, and have them send something into us and showing us that what we have is in error, incomplete, or whatever. Which this reminds me of another problem that we see all the time. Someone's arrested for a crime that, were they convicted of it, it would make them a prohibited person. And again, they are not convicted of that crime for whatever reason. Either it's a complete acquittal, a dismissal, or they plea bargain it down to a non gun prohibiting crime. And then fast forward, 20, 30, 40 or more years, and they try and buy a gun. They go to a gun store and do the 4473 and say, no, I'm not any of those. And their NICS check comes back denied, right? And so we look into it, and what we find a lot of times is that the court never reported a disposition. Okay, and we've talked about this scenario previously today, right? Now here's the twist in this one. The FBI says, we're just reporting what's been reported to us, and if that's not accurate or complete, that's not our fault. Go away. That's what the FBI says. Right. And so we go back to the court, who handled the case initially, some 20 or more years ago, and tell them what's going on, and say, we'd like to have the disposition reported to the FBI, to your state Department of Justice, and then ultimately to the FBI. And the court clerk says, well, we'd be glad to do that for you, counselor, except we destroyed the records 10 years ago. Okay?
Shoot.
And so,
Yeah.
We have nothing to report. And so now this person was banned for life from possessing firearms for an arrest that did not result in a prohibited person outcome. And because the government destroyed the records, and it doesn't matter from my perspective whether it's the state government or the federal government, because the government destroyed the records, now this person is prohibited from their Second Amendment rights for the rest of their life. So I think that the law there should be changed, either through legislation or litigation, one or the other, to put the burden on the federal government or on the government to prove their person is a prohibited person if they want to deprive them of their constitutional rights.
Which no one can prove anything, and then it really comes down to,
no.
at the end.
See, the point is, it's not that nobody can prove anything. It's that the government can't carry its burden. The individual shouldn't have any burden at all to prove that they're not prohibited. It's the government that should have to prove that the person is prohibited. And if the government can't prove that, then the person is not prohibited automatically.
Then if the FBI is the one who's saying, no, Mr. Jones, you can't purchase a gun, the FBI should be the one who is able to show why he isn't?
Correct.
Okay.
Or ultimately, even if you buy the FBI's argument that we're just a repository of documents, it should be it should go back to the state, and the state should have to be able to provide documents that show the person is prohibited, because if the rule should be, unless the government proves, and it doesn't matter whether it's the state government or the federal government, unless the government proves that a person is prohibited, their constitutional rights should not be infringed.
Right, which means being able to walk into a gun store, pass an instant background check, and
Correct.
walk out of there with your Glock.
Correct.
Or whatever you preferred. And that's not happening. Mm-hmm. Yeah.
So there's a lot more work
you
to
also
do.
mentioned you also mentioned ATF reforms, which I thought was very interesting, because a few days ago, I believe it was Boebert out of Colorado introduced H.R. 129 to abolish the ATF, and of course I'm not too optimistic because I think our margins are too slim. Are you at all optimistic that there might be that there might be reforms of that agency?
Well, I'm not optimistic that the ATF is going to go away either. As for today, the most important case that affects the ATF, that's likely to have an effect, has nothing to do with firearms.
No.
It has something to do with fishermen, right?
Indeed.
You know what I'm talking
Yes.
about.
I do.
Local Bright Industries, or Enterprises, is a case that overturned a Supreme Court case that overturned another case, which was the Chevron case. And what Chevron said is that when a regulation that's promulgated by an agency, i.e. a executive branch agency, is challenged by one of us citizens, unless the interpretation of the statute that upon which the regulation is based, unless our interpretation of that statute is so far out in left field that nobody's going to believe it, we're entitled to deference, and essentially the statute is valid, or the regulation is valid. Okay, and so that became known as Chevron deference. Okay, well, Loper Bright overturned Chevron, and Loper Bright says effectively, well, now when a person challenges an agency action, the agency is on equal footing, or the plaintiff, the citizen, is on equal footing with the agency. Okay, and nobody gets a presumption of constitutionality or lawfulness. Okay, whoever has to prove their case and let the chips fall where they may. Okay, so,
which is why the plaintiff went to the court in the first place.
Exactly.
Not to ask what the agency thought, but to ask what the court thought.
Exactly. So this leads into a bigger can of worms. Okay, we might get a lot of regulations, ATF regulations, fixed, rescinded, or not enacted in the first place, because now the ATF has to be more careful about what it does. All right?
Okay.
That's not going to fix the bigger problem, though. And the bigger problem, and this is well beyond the scope of firearms, is that this whole idea of agencies making laws, and adjudicating laws through their administrative procedures, that whole idea is unconstitutional. Not because the Supreme Court has said so, but because the text of the Constitution says so.
Yeah, they're making law.
Yeah, so they're not, it's worse than that. They're not just making law, they're acting as a judiciary as well. So an executive agency, pick your three-letter agency of preference.
The EPA, whatever.
Right.
Yeah.
So they're not just enforcing the law, which is what the executive branch should be doing. They're making law through their administrative rules and these regulations. And then if you come under their microscope and allegedly violate one of those rules, before you can go to your federal district court across the street and file a lawsuit, you have to go through their administrative procedures process. And this is the hen garden, the fox garden hen house, right? You have an administrative judge who works for the executive agency whose regulation you're challenging, and who pays their salary, telling you that you're wrong, right? And you have to go through this process before you can go across the street and sue, across the street to a real court and sue. And you see these administrative tribunals do this all the time. And, of course, perhaps the judiciary likes it to some extent because it takes some work off their plate and they don't have to work so hard for what they get. But from a constitutional perspective, it just doesn't work.
Yeah. Yeah. It really makes you wonder how we could get back to what the founders intended for us.
Well, that's the question. But the problem is it didn't take us 4 years or whatever to get here. It's taken us many years to get here.
Yeah. Yeah.
And so
Yeah.
we have a hard road to hoe here. Not to get political, but a lot of people are happy about the outcome of the recent election. But as good as that is, that's just barely a starting point. There are a lot of things that have to change on a permanent, long-term basis for this to mean anything.
I'm not feeling so optimistic now.
Well, like I tell my clients often, is that I'm not here to make you feel good. I'm just here to tell you the truth, and to kind of expose, pull the curtain back a little bit on what's going on. If more Americans understood their history and their Constitution, that could do nothing but help us, I think.
Indeed. Yes, I agree with that. And like you said, you kind of wanted to pull the curtain back and let us see the man behind the man behind the green screen, as it were, pulling the strings. And I think that is important, because that's one reason it's so intimidating to the layperson is we understand that it's off course, but we don't really understand how all that power is being brought against us. We just know we're getting convicted.
The government has enormous power, and the best course of action, and I tell clients this also all the time, the best course of action is to not stand by your rights and fall on your sword. The best action, I think, a lot of times, is to stay under the radar and stay legal, but don't draw attention to yourself. Exercise your rights, but don't draw attention to yourself. Blend in and go about your life.
Mm-hmm. Yep, good point. And maybe not plead without knowing what the implications are of accepting that plea offer. It may not be in your best interest.
And nothing against criminal defense lawyers in general. I don't consider myself a criminal defense lawyer, although we handle criminal cases. But a lot of times criminal defense lawyers don't understand or fully appreciate the implications of an outcome of a criminal case on a person's gun rights. Well, for the most part too, a very high percentage of criminal cases in the trial courts are handled by public defenders. Okay, those are government lawyers that are paid a government salary, and they've got cases upon cases piled upon them, and they've got neither the time nor the resources to give any case the attention it really deserves. Okay, and that's a topic for another day, but that's the sad reality.
Mm-hmm. Well, and you bring to that a client who may not be thinking the long-term implications, or who doesn't understand their constitutional rights. That person's not going to have the wherewithal to stand up to that kind of counsel. Well, Menashe, it makes me so much more grateful for the work you do, and that people like you exist and are out there fighting for us. Thank you for everything you do for us, and thank you for sharing those perspectives and helping us understand that evolution, even if I'm not as optimistic as I was when we started.
Well, thank you and the network for all that you do in bringing firearms owners together and have a place to get information and resources. What you do is very valuable to the firearms community, I believe.
Talk to us a little bit about where we can learn more about you and your work.
Sure, great. Thanks for asking. We are a Texas law firm, and that's where we do most of our work is in Texas and with Texas clients. But we're pleased to announce also that we've now expanded. We have a new practice group to reach people nationwide. And for our Texas clients, you can reach us at armeddefenselaw.com. And there we can handle anything that arises in Texas legally speaking. And for clients outside of Texas, our new website there is federalfirearmslaw.com. And where we can help people from Texas and the other 49 states is in matters that deal only with federal law. So if, for example, a person has trouble with the passing a NICS test because of a state conviction, we're not dealing with the state law because that's already settled. We're dealing with the federal law, how that conviction applies to their federal rights with the FBI and their criminal history reports, that kind of thing. Federal firearms dealers that get audited and so forth, that's federal law, and so we can help them with that nationwide. And so armeddefenselaw.com for Texas, federalfirearmslaw.com for everybody, and to reach us by telephone, 972-292-7425.